Thank you, Your Honor. I agree that those are the three remaining issues, and I believe we can at least take the testimony from Ms. Bashcroft today. The state may, depending on her testimony, may be requesting time to submit a written response.
Fine. We'll take testimony today from the defense witness or potential defense expert, and then we'll schedule accordingly related to the state's expert and the motion that was filed originally early on in this case in November of 2019. So if the defense is ready, we'll swear in the witness. Is the defense ready?
Yes.
Raise your right hand, ma'am. You solemnly swear testimony you give today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, if you could state and spell your first and last name, please.
Dr. Jacqueline, Jacqueline Bashkoff, Bashkoff as in Frank.
All right, the defense can proceed.
Doctor, can you tell us what your profession is?
I'm a New York State licensed psychologist.
And how long have you been licensed to practice psychology?
Since February of 1982, 39 years ago.
And can you just briefly tell us what degrees you got in your education?
I have a bachelor's in psychology, a master's in counseling and personnel services, a certificate of advanced graduate study, that's another 30 credits, and a doctorate in psychology that I received in 1981 and sat for the exam in 1982.
Okay, I'm going to mark this as Exhibit 1, which I believe you have a copy that was e-filed of your CV. Can you identify Exhibit 1 for us?
Judge, I'll stipulate to the admission of Exhibit 1.
Fine. Exhibit 1 says CV. It's admitted, received.
So rather than going through everything on your CV, I'm just going to sort of focus in on a number of things. What is your current practice right now?
I'm a forensic psychologist.
And does that involve are you publicly employed or in a private practice?
I'm in private practice. I have some contracts with certain agencies, but I'm a forensic psychologist and focus on where psychology and the law overlap.
And at some point in your career, have you also been employed for the Department of Corrections?
Yes, I worked for the New York State Department of Corrections, and I was director of psychological screening.
And what professional affiliations do you have?
I belong to the American Psychological Association. It's Division 41, which is forensic psychology. I belong to APSAC, APSAC, American Professional Society Against Child Abuse, ATSA, Associate. I have to go slower.
Hang on, doctor. Yeah, if you could go a little slower, given the interpreters and my reporter, can you sort of step back a few sentences and start over?
Sure. I belong to the APA, American Psychological Association. I belong to the Division of Forensic Psychology of the APA, which is Division 41. I belong to APSAC, APSAC, which stands for American Professional Society Against Child Abuse. I belong to ATSA, which is the Association for the Treatment of Sex Abusers. I also belong to a local association called the Psychological Association of Northeastern New York, and another national one AFCC, Association of Family and Conciliation Courts.
Thank you. Have you ever taught in the area of psychology?
Your
I-
Honor, I would object that the area of psychology is exceptionally broad, and we're here about child forensic interviews. We also all have her 4-page CV. So I would ask that the question be narrowed.
So, all right, we
Well,
can,
fine, you can narrow it down. I mean, yes, psychology is broad. That's like, have you ever been a judge? Yes. More narrowly, have you presided in a homicide court? Yes. So go ahead, Mr. Buting.
sure. Have you had, let's talk about training for a minute. Have you had any training in the methods or techniques for child forensic interviews?
Yes.
And what does that involve?
So in the early 1980s, when I was the chief psychologist for Albany County Mental Health Clinic, I was on the first incest task force where we started learning methods of child forensic interviewing. I also took the multi-day course on New York State's best practice for child forensic interviewing. I've acquired specialized knowledge over the last 40 years where I attend conferences yearly, keep up on the literature. The New York State Troopers is about a mile away from my office. Prior to the pandemic, every fall and every spring, they have a special section. It's a week-long program on child forensic interviewing, child sexual assault, interview methods. There's forensic psychologists that speak. There's lawyers that specialize. I also belong to AFCC, where there's a yearly conference. And because I do a lot of custody evaluations, there's allegations of sexual abuse sometimes in contested custodies. So I attend those conferences. Every time I'm asked to review a child forensic tape, I review the literature again. I have to keep up on the literature as it pertains to child forensic interviewing. And I also taught at Cardozo Law School, it's in Manhattan, on child forensic interviewing and peer reviews of child forensic interviews.
Now, we'll talk about what those interviews entail in a second, but do you actually conduct or have you conducted child forensic interviews yourself?
I've been conducting the child forensic interviews since the early 80s, yes.
And how is it that you are asked to do those?
Well, early in the 80s, we didn't have child advocacy centers. So as part of my job at Albany County Mental Health Clinic, I was a liaison to the Albany County Jail, Albany County Family Court, Albany County Probation, Albany County DSS, Department of Social Services. So I was doing evaluations back then. Back then they were called sexual validations, but we saw how prejudicial even the name was, sexual validation. So about 10 years ago, we started calling them child forensic interviews. I get my referrals from criminal defense attorneys, family courts, public defenders' offices, the federal government. And we don't have as many child advocacy centers in New York State, unfortunately, as you do across the country that I've become aware of. So I am still called upon to do them in my own private practice.
Okay, so about how many child forensic interviews do you think you've done in your career?
Between 600 and 700. I've been at this since about 40 years now, so.
Okay. And about how many on a yearly basis would you say?
About 20 a year, 15 to 20, something like that.
Okay. Now, when you were asked to, let's focus on it for a minute on evaluating other people's interviews that have been done that are tape recorded or video recorded. How is it you come about doing those?
So I have a national reputation for doing child forensic interviews and critiquing them. So I'll have an attorney send me, first they call, ask me if I'm interested, and I will tell them to send me whatever records they have and the videotapes. They send the materials, and I have found that, I can't help in every case, but a lot of the attorneys who have worked in this area, so they send me sort of a self-selected group of videos because they already believe there's a deficit. But sometimes I don't see the deficit, so I will call them back and say that I can't assist, that the interview was done according to the national protocols. And then sometimes attorneys will send me what they think is a good interview, and they really just want confirmation. Do I think it's a good interview also? So sometimes I'll get those kind of requests as well.
Okay, and do you also have a therapy practice?
I do 2 days a week. I do therapy with perpetrators of sexual abuse and complainants. I also have some general anxiety and depression cases. The other 3 days a week, I do all forensic evaluations, and Saturday and Sunday, I write them up.
And when you do treatments of victims of sexual assault, what kind of age range have you been involved with?
From 4 years old all the way up to seniors.
Okay. Have you ever testified as an expert in a case where there were allegations of child abuse?
Yes.
Have you given testimony, expert testimony before regarding your review of child forensic interviews?
Absolutely, many times.
And in what jurisdictions have you been qualified as an expert before?
19, I think about 19 counties in New York State the last time I checked. I've also given expert testimony in California, North Carolina, Oklahoma several times, Wisconsin several times. Even in Japan, I've done about 5 courts martial, and one was in a U.S. Navy base an hour outside of Tokyo. I've consulted on cases in the state of Washington, Minnesota, but the other ones is where I've given, and Texas, I gave testimony on child forensic interview, and some of these states several times.
And have you ever been qualified as an expert and given testimony in the specific area of child forensic interview techniques?
Yes. Sometimes I'm just brought in as an expert on just the topic.
Can you explain what a child forensic interview is?
It is an interview which has developed on scientifically structured and legally sound applications of methods on how to investigate a crime. So it's basically a scientifically structured and legally sound application of methods when investigative methods to look at a crime.
And what are sort of the stages, or what's the purpose of doing this kind of an interview?
So it's to look for reliability of the complaining witnesses' allegations. It's simple in terms of the stages. Rapport is being built between the interviewer and the child. The interviewer is supposed to remain virtually a blank screen so that the child can tell their narrative and not just confirm a conclusion or hypothesis that the investigator has. The investigation is supposed to be very open-ended. That's the golden standard, open-ended questions, so the child can absolutely share their independent recollection and not just confirm what a hypothesis that the interviewer may or may not have. All the, and I'm sorry, go ahead.
Have these interview techniques been empirically reviewed?
Yes, and there's the research is more than 30 years old at this point. In the early 1980s, there was everybody is, I'm sure, aware of sexual abuse allegations. There was a frenzy. There were famous cases like the McMartin preschool out in California, People versus Kelly Michaels in New Jersey, Country Day Walk in Florida. And when all the cases, a lot of media, repetitive questioning, lots of interviews of each child. So when they went back and looked at how the interviews were conducted, realizing that the style of interviewing was correlated with the answer that the child would give, the research began on what types of questions would be reliable, what are the best practice methods. So a lot of research was done on what type of questions are standards, like watch for confirmatory bias, watch for memory issues, watch out for suggestive questioning, close-ended leading questioning, any kind of post-event information that the child may have received. So there's a lot of research on all different aspects, and out of the empirical research came protocols, nationally accepted protocols.
And are you familiar with the studies and the research that was done in order to come up with those protocols?
I am, and they use the scientific method. And so they would have a hypothesis. They would test the hypothesis, just the same as the interviews should. There's also, in the research, there was blind testing. Children were put in control groups where they weren't told the same as the subject group. Reports made, it's peer reviewed, the results are peer reviewed, and it's either capable of being replicated or it gets refuted. So the scientific method is used with all of the variables and coming up with the national protocols because of all the false allegations of sexual abuse that arose out of the early 80s.
Okay, now has the research determined that there are ways for questioning a child that to get reliable information that are maybe counterintuitive to what a layperson might think?
Your Honor, I'm going to object to the use of the phrase research. I'd ask that counsel specifically cite a study, so I know what he's talking about, as opposed to, as the witness testified, 40 years of research.
Well, I think the question is broader. It's in the context of, has the collective body of research, it's evolved over the years.
Right, overruled. The research is always changing, evolving, in my experience, and Ms. Carson will get a chance to cross in a little while, so overruled. You can answer if you know the answer to that, Doctor.
Yes, this type of specialized area would be beyond the ken of the jury. They would not understand that repetitive questioning in the literature by Istanbul and Blades, Poole and Lindsay, that Poole and White, that repetitive questioning will suggest to the child to change an answer. So a lay person might not know that. A close-ended question, a lay person might not know that. It certainly doesn't give the child, it's not the child's narrative. The interviewer is actually using more words than the child. The child just has to nod yes or no. The layperson, it would be, would not know what the research says about leading questioning. Leading questions are questions where it's obvious what the interviewer wants to be answered. Did he touch you on your nose would be a leading question. And if a person said yes or no, a jury would not know that leading questions are just the confirmation of the child and not really the child's independent experience. They need to know that children also acquiesce to authority. So children confabulate, they fill in spaces. Do you know where John was? Many times a child will, instead of saying, I don't know where John was, will say maybe in the TV room, maybe in the bedroom. So the jury would need to know information, the research on leading questions, suggestive, repetitive, confabulation, confirmatory bias. They would never be able to, the man on the street wouldn't know those kinds of terms.
And particularly with how those, let's say, improper or those types of questions might be more problematic when you're dealing with a child as opposed to an adult, for instance.
Sure, a child's more easily led. It's not are children suggestible, it's how suggestible they are under what conditions. A child's more easily led than an adult.
Okay. And so has this research then that began back in the 80s even and has evolved, determined that there are sort of right and wrong ways to question a child in order to get reliable information?
Yes.
And in a, particularly in a child abuse scenario, are these different right and wrong ways of questioning a child the sort of thing that lay people would typically know?
They wouldn't know. They
Okay.
absolutely wouldn't know.
And has it been found that poor questioning techniques might affect the memory of a child?
There's a lot of, it's multi-determined. The most important thing, the way the question is posed will predict the quality of the answer. So it depends on what authority figure. Is it an interviewer, a police officer? There's certainly authority figures might get children to acquiesce more than a peer. So there's a lot of data on who should be doing the questioning. Certainly the skill level of the interviewer is paramount to the reliability of the information. See.
Okay, and then so have there developed sort of nationally accepted protocols for questioning children?
Yes, there are.
And do those vary from state to state? Is there overlap?
So there's a lot of overlap. One of the nationally accepted ones is called the ABSAC, American Professional Society Against Child Abuse. And the Wisconsin guidelines were based on ABSAC. So there's a lot of overlap. New York State's is based on ABSAC. Wisconsin also in the materials are based on the United Juvenile. It was a brochure that was in their materials. A lot of overlap, and the Wisconsin guidelines definitely fits the same as the ABSAC guidelines. So there's overlap and there's golden standards in all of them.
So can you give me an example of techniques that are universally recommended in these protocols?
So in every protocol, open-ended questions is the golden standard. You often hear this word called funnel approach, that you start with open-ended questions, especially with 3-year-olds. You might have to then go more and more close-ended because they don't have the cognitive capacity to share. So as the child gets older, they can be a better historian, and open-ended questions will get the most reliable information, not tainted by bias of the interviewer. No leading questions is in every protocol. Leading question absolutely suggests to the child the right answer. And so you still have to be a blank screen so that they can give their narrative and not just confirm the interviewer's narrative. Alternative hypotheses is in the Wisconsin protocol and ABSAC and New York State's. It's the scientific method. So you want to look for alternative explanations for what the child is saying. You look for alternative explanations of what the child is saying may be contradictory or nonsensical. So you look for alternative explanations so that you gather more and more information of what the child experienced.
Now, is there some way in which the interviewer is supposed to control for the possibility of contamination of information?
If an interviewer follows the protocol, that will reduce contamination. If they remain objective, that will reduce contamination. If their body language is neutral, that will reduce contamination. So if you follow the protocol, there's no perfect interview, but if you follow the protocol, you'll reduce these errors.
So the idea then is to minimize the potential of distorting or leading the child's in its whatever the child is saying.
You want to minimize trauma for the child, maximize the most reliable information that you can get from the child, stay as objective and neutral so the information's not contaminated. You want to maintain the integrity of the information for agency use, legal proceedings. There's not a lot of things that's the child forensic interview, but you want to maintain the integrity. And so it's not tainted, it's not compromised, so it can be also assist a trier of fact if it goes to trial.
Okay, and if the interview is not conducted properly, what's the risk of an outcome?
False allegations. You can end up with people who are innocent who are seen as guilty, people who are guilty who end up being seen as innocent. So it swings both ways, that you could end up with false positives and false negatives. So it's very important that the protocols are followed. They're based on empirical methods. And if they're followed, it reduces contamination, so you have a better outcome.
Okay. So what about the possibility of confirmatory bias? What is confirmatory bias?
Confirmatory bias exists in everyone. It's to what extent, and you have to know what your biases are before you start an interview like this. Confirmatory bias is when somebody looks for information that will support their hypothesis and ignore information which is not consistent with their conclusion. So confirmatory bias is you shine the light only where you want to see and not where maybe you don't want to see.
And is that something that it's just a matter of human nature that we're all subject to?
We all have biases, implicit, confirmatory, and you just have to understand what they are, and you can reduce bias by not using leading questions, not using close-ended, considering alternative hypotheses, considering where the child's getting the information from. There's a way to reduce confirmatory bias, even body language.
And has the issue of confirmatory bias, is that something that's also been researched, studied by?
Confirmatory bias has been researched many times. Stephen Ceci, CECI, and Maggie Brook.
BRUC, it's BRUCK.
It's BRUCK. And Deborah Poole, POOLE, and Michael Lamb wrote a book, plus they both have done a lot of research on their own, but talks about confirmatory bias. It's everybody who does a child forensic interview has to understand that term, because it's different than a police interrogation. It's a child forensic interview is the child's narrative. The child is telling the story.
Okay, what is source misattribution?
Okay, so source misattribution, misinformation, they call it source monitoring also, is where the child's memory is malleable, especially by parents, authority figures, teachers. And so they've done research that shows that a child has heard information, even from naturally occurring conversations, like overhearing a parent on the phone, listening to a neighbor. A lot of the research was done by Elizabeth Loftus, who is very well known, but there was a study with Pickerell, I think it's Pickerell, Bernstein, and Loftus about misinformation effect. Principe, PRINCIPE, and Schwinde, SCHINDE, I think that's 2012, about how parents' naturally occurring conversations can be incorporated into the child's memory. So the child will say something, and it's not that they've experienced, but now they've incorporated it into their own memory, and the source of where it came from is not their own, but it's been incorporated.
And then if that occurs, that is, source misattribution occurs before a professional does a child forensic interview, can that affect the reliability of the information that's obtained from that interview?
Absolutely. That's why the protocols say to do data collection ahead of time. Who does the child talk to? Who's in the family? You understand the who else has interviewed, so that you can bring that up in the interview as well. Who else knows? Tell me, did you tell this? Who did you tell this story to? Tell me what you said. Open-ended.
And if that happens and the child talks to a number of other people, does that actually, or can that actually affect the child's memory at the point that they are later being asked in a forensic interview or in a courtroom or wherever it might be?
Sure. And children will say with great conviction that they saw something or heard something when they haven't experienced it. And, we have the mousetrap experiment.
That's mousetrap, you said?
Mousetrap, right? Briefly, they told children that their finger was caught in a mousetrap. 10 days later, they told the children, they debriefed them and said that it did not happen. And I forget the percentage, it was close, I think 58% or 60, I have to look it up. Were convinced that it did happen, even though it didn't. So we know children are suggestible. Santa Claus, Easter Bunny, Tooth Fairy. So it's just how suggestible and under what conditions.
And then when the child then tells somebody the story that may involve that or may have been affected by that, does it mean that they're lying, or do they believe what they're saying is the truth?
The child believes what they're saying is the truth. If they've repeated it enough, if they talk to enough people, they incorporate it as their own memory.
Okay, so let's turn to this particular case involving Keith Kenyon. What were you asked to do in your review of this case?
I was asked to review the tapes, the child forensic interview tape, and assess whether it met with the standard protocols, with the standards for the nationally accepted protocols, including the Wisconsin ones.
Okay, and what materials did you receive and review as you were consulted in this case, if you recall?
Yeah, I would have to refresh my memory. There was a lot of things. On the first page of my letter, it says what I reviewed. I think there was 7 things.
Okay, let's stop right then and go ahead and introduce Exhibit 2.
That's fine.
Introducing Exhibit 2, can you identify, well, you don't have it in front of you, but it's it was attached to the notice of defense expert disclosure.
Yes.
What exactly is that?
So can I refresh my memory?
Do you have it with you?
I do.
Okay, yes, sure.
Yes.
Thank
Okay.
The victim tape, the criminal complaint, the order allowing access to evidence to protective order. And I think I have a typo here. I don't know where I got Norwalk. I think it was Wisconsin Police Department arrest detention report, or the name of the county. I don't know where I got Norwalk from, but
I'm sorry, the typo is, it says Norwalk, Norwalk, Police Department, and that was just a typo.
that's a typo. I don't remember if it was the county that it came from or I don't remember what it was, but I know it's not Norwalk. But it was the police department arrest detention report.
So that would have been the Milwaukee Police Department?
Milwaukee Police Department, thank you.
Okay.
3 tapes regarding Mr. Kenyon, body cam videos, pictures of the home and evidence audit trail, and the Wisconsin Child Forensic Interview Guidelines.
And then did you submit a letter to myself summarizing some of your conclusions?
I did.
And that's what we've marked as Exhibit 2. Yes. Okay. As you reviewed the videotape interview of the child, and we're not going to use the name of the child on the record, it's just initials or the child, if you would, Doctor. Did you see any errors with the method or the way the interviewer conducted this particular interview?
I did.
I'm sorry?
I did.
Okay. Let me go through a few issues. Did you see any issue with confirmatory bias on the part of this interviewer?
Yes, she did not explore any alternative hypotheses at all. She didn't ask for clarification on information that might not have been consistent with a crime being committed. She, at the end of the tape, the little KW says that her mother says this is illegal, and the police officer validates it for her and says, and your mom is correct. So she has already said that the plaintiff is, the defendant is, has committed a crime. The child says something like, it is illegal. My mom said it's illegal, and the police officer confirms it at the end of the interview, which is
Okay,
Sure.
can we
Bias.
just stop for a minute? Counsel, can we introduce the transcript sealed? It's e-filed and sealed.
For purposes of this hearing, I have no objection.
Okay. Let me mark that.
Is this the transcript of the forensic interview?
Yes. And I'm also going to, I've got two exhibits here. Exhibit 4 is the transcript of the forensic interview. And exhibit 3 is a flash drive of the actual interview that I'm going to go ahead and file.
Fine. Any objection to those?
No?
All right, they're both received.
So it's a little bit easier for the court to follow along with examples that you find. You were talking about something, my notes, let's see here. Trying to find where you said your mom is correct about that.
page 18. And it's about 6 sentences down. KW says, my mom said it was illegal for him to do that. Investigator says, and your mom is correct about that.
Okay, I'm missing page 18 in my copy. I just want to make sure that, did I give the court the right ones?
Page 18,
Yes.
1-8. Right, I see that. It's in the middle of the page on page 18.
Okay, thank you.
Whoever's enumerated as K, quote, my mom said it was illegal for him to do that. And then I think interviewer, quote, and your mom is correct about that, end quote. All right, go ahead.
Okay, thank you. And is there something wrong with doing that for the
Well,
interviewer?
It speaks for itself. She's confirming for the child that the defendant has done something illegal, and this is only one piece of the investigation. The investigation has just started.
Okay. Was there any questionable body language that the interviewer displayed, or nonverbal gestures or anything of that nature?
Yes, and give me 1 second to. Page 14. 5 sentences up. The investigator says, when you say a onesie, is that like a full one-piece outfit and it's time stamped at 1:59:20? The investigator makes a motion of zipping a zipper all the way down to her boot. The next sentence is,
To her what?
she makes a motion of zipping a onesie all the way down to her shoe, the bottom of her shoe. Now, the child has not introduced this at all, which is also inappropriate interviewing. The interviewer is never to suggest any evidence. It's supposed to come from the child. And then the child responds, KW, yeah. And then there's like a zipper that leads down to your leg. And it's stamped 1:59:23. The child shows the zipper just going like towards her belly button and stops right there. So it's certainly biased that the interviewer's body language, because it fits with her hypothesis that the zipper goes all the way down to the foot, while the child has never said that, has never introduced that. That's in the Wisconsin guidelines and ABSAC. The interviewer is never to suggest evidence because of confirmatory bias. The child will acquiesce to please authority figure, and so that's
Is there,
a problem with the interview.
okay. Is there also any leading or suggestive questioning about this issue of unzipping and the underwear that is also shows confirmatory bias by the officer?
So this is a 30-minute interview, which is right in line, 3 to 4 minutes for each of for the child's age. So it's a 30-minute interview. So you figure it's going to be about a 32-minute, 3 to 4 minutes for each age of the child, or they get exhausted and fatigued. On page 10, in the middle of the paragraph, page 1, 2, 3, 4, 5, 6, 7, 8, 9. Line 9, KW says, well, he took off my underwear. Then he took some cloths, he wiped it, and then he licked it and left. So.
Okay. And then
if you look at page 11, the fourth sentence, the interviewer, now the child has never said that the onesie is taken off, and obviously to get access to the vagina, you're going to have to unzip, and you're going to have to take this to get her underwear off. She said her underwear was taken off. You're going to have to take off the onesie to some extent to get the underwear off. So
because the onesie involves your foot being inside the onesie.
Yeah, you're both a onesie. Your feet are both encapsulated in a pajama type of thing. And so when the child says he took my underwear off, it doesn't fit with the hypothesis that how do you get, if you didn't take your onesie off, how do you get access to the vagina? So the investigator says, and I heard you say did you say he took your off, down, or something else? She already said that he took her underwear off. So now we're into a leading suggestive question that's now repetitive. And the research, which I've already said on repetitive questioning, is the child thinks they have the wrong answer, so they change their answer. Inevitably, this child changes her answer and says, he just moved it, the next sentence, he just moved the part, he moved it a little. So now she has taken back that he took her underwear off, And now the child says he just moved the part, he moved it a little. This is a different answer, consistent with the research. Poole and Lindsay, Istanbul and Blades, that if you ask a question twice, the child thinks they got it wrong, and it's perfectly done here. She changes her answer to takes her underwear off to he moved the part, he moved it a little.
Okay. So is that an example where the improper questioning actually alters the response of the child?
It speaks for itself. It did alter it. It's very
Okay.
clear. It's very clear. She said took underwear off, and now she's changing her story after that question.
Okay. You mentioned when we were talking more generally about some of the stages of these questioning techniques that there's a rapport building or some sort of a narrative discussion. Tell me, can you explain first why they do that in these interview protocols?
Sure. They do what's called a narrative practice event. They ask the child to discuss something neutral that has nothing to do with any allegation, so that they can see their level of cognitive capacity, their language, if there's learning disabilities, if there's concentration. So in this case, the child gives two very, very detailed discussions. One is about a video, and that was 8 or 9 sentences long, excuse me. And then one is about a field trip, and that's about 18 sentences long. Nowhere in this disclosure does this child give any details like she's capable of doing. Now, a jury would not.
I'm sorry, when you say nowhere in this disclosure, what part of are you speaking of? The disclosure of the sexual contact part?
That when the child says that he took my underwear off, these are sentences. They're not paragraphs. They're not narratives. They're one-word answers, especially if there's a close-ended question. But you can see this child has no learning disabilities. She tells detail about a video game and detail about a field trip. So she has the cognitive intellectual capacity to provide details. And this is an impoverished, very impoverished disclosure, outcry.
Disclosure of the sexual contact part, you mean?
Right, exactly.
Okay. And is that something that should have been followed up, or, a red flag for the interviewer, or does that indicate confirmative bias to you in what way?
Well, this is a 30-minute interview, and I believe more than half is spent on a rapport and narrative event. So the things that are missing is who does this child live with? This is it's a contextual interview. There's no discussion of, does she have a mother, a father, sisters, brothers? Who does she live with? Is not here at all. Because she says he moved it over a little, that also should be explored. Easy way to explore is you bring out anatomically correct drawing, not a doll. There's too much controversy about dolls, but a drawing, so we know what she means by vagina. That would be very helpful.
Was it an anatomical drawing used at all in this interview?
Not at all, not at all. No alternative hypotheses, no anatomy, no family constellation. The suggestive, she says, I'll get the page. The interviewer is never to suggest evidence. It's the child's story. So she asks if he used his hands. The child never said he used his hands. She asked if the child used his hands. She said, then, did he use his mouth besides licking for anything else? The child, she could just say to the child,
Could we just stop and find the page on that?
I want to start from the beginning because I don't want to get this wrong.
Page 11, I think it is.
Right, page 11.
Um,
Okay, near 1, 2, 3,
Near the bottom.
yeah, 3 at the bottom. The investigator says, okay, did anything happen with mouths besides licking? That's suggestive and close-ended. 2 sentences above. Did anything, well, that's a compound sentence that shouldn't be asked to an 8-year-old. The lights were off. Okay. Did anything happen? With hands. She's suggesting evidence that the defendant did something with their hands, and it's a close-ended question. It's just improper. It's improper questioning. So the reliability of the answers are questionable.
Can we, you talked about some leading or suggestive questions. Was there also something, I think it's on page 15, about skin? Let's see.
Yeah. So as I stated before, in the Wisconsin protocols, in all the national protocols, the interviewer is not to suggest crimes. They're not to suggest evidence. So the 4th sentence down, the interviewer says, now the child has never used the word skin, has never used the word tongue. Okay, so was it skin to skin, like his tongue on your skin? Did I get that right? So that's the investigator's premise, that it was skin to skin, tongue on your skin. Did I get that right? And does it give the child any room to give an open answer? The child doesn't even say yes or no, but just nods affirmatively. So that's just a leading and suggestive question. And it has all the elements of confirmatory bias, leading and suggestive, and close-ended.
And just a couple of lines above that, is there also?
Yes. So on the top of that page, the investigator says, okay, and you said he unzipped it. The child never said, oh wait, the child did say unzipped it. He moved your underwear to the side and licked your vagina 1 time. The child, that's a close-ended question. The child affirmatively, says, nods yes.
Now, is that was that a repetitive question?
I don't find that so problematic. It's repetitive, but it's close-ended. She's just repeating that the child did say move a little, but she's being much more elaborate than the child. The child just said moved a little. This is, the investigator saying moved your underwear. The child was really specific and said moved a little.
Okay. And then a few lines down from that, does the officer introduce anything about zipping?
So the child in the beginning says her uncle unzipped the onesie, wiped it, and licked it once. The investigator says, did you say he zipped it back up or you zipped it back up? Well, the child didn't say any of those things. Again, it's suggesting evidence, it's leading, and it's close-ended. And then the child, to fill in the blanks, he zipped it back up. We don't know. She didn't say that in the beginning because she wasn't given open-ended questions. It makes the information questionable and unreliable because we don't know whose story. Is this the investigator's story or the child's story?
Okay. You mentioned some things that weren't asked, such as the family tree or who lives in the home. Why are those questions, or why should have those questions have been asked?
Well, you're going to try to generate a number of hypotheses, not go into an interview with a conclusion, but go in and to get your conclusion validated, you're going to go in with several hypotheses. It's important to know who the child lives with. It's important to know mom and dad in the house, are there sisters or brothers or the dogs, their grandparents, to generate alternative explanations, and still for contextually to understand where the child lives.
And even to find out if there might be somebody else who's the perpetrator that lives in the home?
That could be another hypothesis. It's just a void, and you always find out because you want to know who the child talked to. So who do you live with? It was absent, and that's you always ask in rapport building everybody's name, what the relationships are. It's part of every evaluation.
And were there other areas that were not explored?
Well, she says her 6-year-old cousin Abby was sleeping in bed with her. I would want to know more about, were they right next to each other? Tell me how the bed was, tell me where it was in the room. Tell me about blankets. Tell me about, did Abby wake up? Tell me what you did the next morning. You're supposed to go from the beginning to the middle to the end, so have the full picture. She has an aunt in the house. The child does mention the aunt, but when the interviewer tells her in the beginning that she should not guess, which is a perfectly fine rule, you're not supposed to guess. On page 15, around the middle of the page, the aunt's name is Megan. Okay, the police officer says, okay, where was Megan when you guys were watching the movie? She says, I think she was in bed. You think she was in bed? Either downstairs, so they have 2 TV rooms, one upstairs across from Allie's room and one downstairs. Megan was either watching TV downstairs or in her bed. So that's the child's obviously guessing. She doesn't know where the aunt is because those are 2 different places.
Did the interviewer question her about that or stop her and say, I don't want you to guess? Or
No, she did not. No, she did not.
Okay.
I would want to know what triggered her talking about the event that day, 4.5 months later. Tell me who you told first. Tell me what you said. All tell me questions are open-ended.
Okay.
I would want to know, what rooms she's in. Abby's bedroom. They're in the same bed. When she lays in that bed, can she see her aunt and uncle's bedroom? Could they see into her bedroom? With open-ended questions. Tell me how an easy way to figure out the onesie. tell me how your clothes were, tell me how your pajamas were, but she asked close-ended questions and assumed by the body language. She could have just said, tell me how your pajamas were.
Okay. And does she, at some point, I think it's towards the end of the interview, page 17 at the top. Let's see. The child, there's a discussion about who else knows the story. Do you remember that section?
Yeah.
And what is the and she mentions that other than her mom and dad, several other people know. There's a high school friend, there's a neighbor, there's her grandmother. What's the significance or what's the importance about who else knows the story already?
So we're getting into the area of multiple interviews, multiple interviewers. Sena Garvin, Sena Garvin, Garven, 1998. Every time a child is questioned, they absorb information from whoever they're talking to, and it taints the next interview. Just like we saw in the interview of Mr. Kenyon, the police officer calls it a washcloth, while the child called it a wipe. So that police officer has talked to someone, so now he's already put his twist on. Now it's a washcloth instead of a wipe. She's talked to her Aunt Jenny, who's not really her aunt, but it's a close neighbor. Her father knows. She thinks Joanne's husband may or may not know. She doesn't know, but now she's talked to a lot of people. She's been exposed to whatever her mother said, or her father said. If she has brothers or sisters, whatever they have said. I don't know who lives in the family because it was never explored, so I don't know who else.
Okay. By the way, at the beginning of the interview, does the interviewer identify herself as a police officer?
Yes, she does. Yes, she called. Yes, she interviews. Yeah, she. I don't know why she could have just said, "I'm here to ask you some questions. I talk to kids all the time." But the idea of a police officer as an authority figure. There's also I use the word parentified. It's when children use words that they obviously wouldn't have at age 8. I want to find the word. It was disturbing and something else. Oh, it's a while back. It's a narrative. So on page 8.
Page 8 in the middle?
Yep, in the middle. The child, KW, says, it's very disturbing because my uncle did something illegal. So you start to think about the empirical factors of negative indoctrination, that the child has a negative view, and who used these words, source misattribution. Very disturbing, and for an 8-year-old to put together that it's illegal behavior is, I'm not going to say totally impossible, but unlikely.
Mr. Buting, let me interrupt for a second.
Sure.
Let me just ask if the interpreters need a break. You okay? All right. All right, go ahead.
Thank you. Now, you mentioned when you were talking about materials you reviewed that You reviewed the police reports in the case?
Yes,
And you also, I don't think the police reports talk about this, but you did see the body cams as well?
I did.
And what did you see from the body cams that was concerning about how the investigation began before even the child forensic interview?
The police officer on the porch interviews the child sitting right next to her mother, with her mother rubbing her back.
And this is a uniformed police officer?
Uniformed police officer. It, it absolutely taints what the child's saying. The mother is rubbing her back. And the child, you could see that the child's looking up to the mother for reassurance. She tells the police officer this. The police officer in a few minutes got the same level of detail as the investigator did. It was impoverished. It had limited, if any, detail. But the big problem here is children are not supposed to be interviewed in front of a parent or a guardian unless there's a learning disability, a physical disability, and based on what I reviewed and what I saw, there was no cognitive limitations or physical limitations.
And is it actually part of the protocol that a child's parent is not supposed to be present during a forensic interview?
Not supposed to be present.
And is that something that lay people would generally know is an important factor in obtaining reliable information?
A layperson would not know that it can taint the information, or that you could send signals to the child that this is very traumatic, this is very upsetting. There's a million, not a million, there's a lot of explanations of why she rubbed the child's back, why the child was looking up to her, but she should have not been interviewed in front of her mother. In most jurisdictions, the parents aren't even allowed to look through a one-way camera as well, because then it can, after the interview, if they're getting ready for any kind of legal proceeding, then the parents might have information that might contaminate further the story.
Okay. Almost done here, I think. Let me just see. Oh, just one, going back to on page 11, when there was the question about the multiple choice question. And did you say he took your underwear off, down, or something else? That kind of a multiple choice question, is that appropriate or not?
Well, what was wrong with this question was that when the child said the underwear was taken off, it would not fit with the defendant being able to get access to the child's vagina. So she gave her choices, and inevitably the child did change her answer, because that's the research that multiple choice you're not supposed to give. It's supposed to be the child's story. But in this case, this was particularly contaminating, because the child's story was changed by this question. It went from the underwear was off to the underwear was moved to the side. He moved it a little.
Okay. And so has there been research studies on the effect of both improper interviewing and, the introduction of external information on the reliability of a child's memory about something?
Well, they do act synergistically. If you have leading and suggestive questions and confirmatory bias, Stephen Cece, Elizabeth Loftus's, and Kamala London in this area talk about how memories of children are like they can soak up information, and the combination of improper interviewing acts synergistically to change the child's memory and then therefore the reliability.
Okay, so Dr. Bashkoff, then, in closing, in your professional opinion, what happens to a child forensic interview when there are the things that you've discussed, that is confirmatory bias and impoverished disclosure, leading questions, suggestive questions, close-ended questions, and repetitive questions?
One, it can't be rehabilitated. Once you can't unring the bell, the reliability is in question. This was an impoverished disclosure from a child that had sophisticated and long vocabulary with her video games and her field trip. I question the reliability of the information and if it could assist in a legal proceeding.
Could do what? Assist?
If it could assist the trier of fact based on all the deficits, I question whether it's reliable and competent information to use in a legal proceeding.
And did you see all those factors in the child forensic interview in this case?
I did.
Thank you. I don't have anything further on direct.
Cross. Well, actually, do we need a break?
Okay.
Yes, please.
All right, let's take 5 minutes or 10 minutes. Doctor, we're just going to stretch our legs for 5 or 10 minutes. You can do the same and we'll come back in 5 minutes, 10 minutes.
Thank you.
Thank you, Your Honor.
All right, let's get ready to go back on record. All right, the defense was done with direct, at least for now, and I think Ms. Carson was going to start cross, correct?
Yes, please.
All right, go ahead.
Doctor, you would agree with me that research must be similar to the facts of the case to support an opinion, correct?
Yes,
And you talked a lot about research in the broad sense. You recall that on direct examination?
I named some studies, yes, right, some in the broad sense, but I named studies.
And I just want to go back to your background for a little bit. You indicated that you attend a week-long training put on by the New York State Troopers. Is that correct?
Prior to the pandemic, yes.
Is that specific to conducting forensic interviews?
It's all about child sexual assault. Full days, a
No.
full day every year is on just interviewing, but there's all aspects of child sexual assault.
So my question though, is it specific to interviewing and conducting forensic interviews of children?
All 5 days, no. 1 full day, yes.
And have you been peer reviewed in your work?
I haven't published.
And you indicated that you've testified in Wisconsin several times?
Yes.
How many?
Today's the 5th.
I meant at trial, not at a Daubert hearing.
3.
3 trials in Wisconsin, correct?
Yes.
How many times have you been excluded as testifying as a witness?
0.
And when you talk about testifying in Wisconsin in 3 trials, were those all about forensic interviews or were those on other topics?
All forensic interviews, child forensic interviews.
You also testify about other topics, correct?
Yes.
You testify sometimes about false confessions, correct?
No, I don't testify about false confessions. I was on a national TV show about false confessions, but I haven't testified about false confessions.
Has there ever been a time where you have testified at a Daubert hearing and not at a jury trial?
New York State is a Frye state. I have never testified at a Daubert hearing. This is the first.
You've never testified before at a Daubert hearing?
Never.
You didn't testify at a Daubert hearing in Waukesha County?
No, that was a taint hearing.
You didn't attempt to testify as an expert, and the issue was excluding your testimony as an expert.
No, to my knowledge, this is the first Daubert hearing. I've testified as an expert in many, many cases. It was called a taint hearing.
Really? I mean, it was Mr. Buting's firm. That was the same law firm. You remember that, correct?
At the time of the taint hearing, it was not his law firm.
So it's your testimony that when you testified in Michael Moran, 19 CF 800, it was not at a Daubert hearing.
Correct.
It was what you consider to be a taint hearing.
That's what I was told it was.
Well, you testified about child forensic interviews, correct?
I did. It was a taint hearing, and it was clear that it was a taint hearing, and the word Daubert never even came up.
Were you aware that you testified because there was a motion to exclude or limit your testimony at trial?
Right, and I think it was Judge Durow, Durow, I think that's her name. There was no Daubert hearing, it was a taint hearing.
And you testified on direct that you have contracts with certain agencies. Is that correct?
Yes.
What agencies, ma'am?
The federal government in the Northern District, that's here in Albany and Syracuse, there are 2 upstate. Rensselaer County Department of Social Services, Saratoga Public Defenders, I do other by contract each case, but I have a ongoing contract with those.
And you testified that back in the 80s, there were media and a lot of repetitive interviews that led to issues and started this research into forensic interviews, correct?
That there were cases that were popping up all over the country, McMartin, Kelly Michaels, and it got a lot of attention. The trials were lasting 8 and 9 months. And when they looked at the type of interviewing, research started because they realized that the quality of the question had to do with the child's response. Children were, as you know, Kelly Michaels was convicted, and then it was reversed when William Kunstler argued it, and that it was based on improper interviewing.
There's no media in this case, correct?
No, when I said the word media, I meant video. There was those interviews. Some of them were video, like Kelly Michaels were audio taped, but none videotaped, and that's why now it's the standard that you have to videotape so that you can critique whether it was done correctly.
And counsel asked you questions about leading questions. You recall that?
I do.
And for example, I've been asking you leading questions where the answer is either a yes or a no, correct?
Some cases.
And in the example you gave, your question was, did he touch you on your nose? That's a leading question, correct?
Yes, and close-ended.
And a leading question is one that suggests the answer, correct?
Yes. A leading question.
Close-ended question, you answered my question, thank you.
Okay, thank you.
And a close-ended question would be one that invites just a yes or no answer, correct?
Yes.
And an open-ended question, you gave the example of tell me all about something. Do you recall that?
Yes, I do.
And you agree that that's an open-ended question, correct? I'm sorry?
Yes. Yes, I do.
Now, let's talk about the research. You mentioned the mousetrap study, correct?
Yes.
And you said that children will say things with great conviction, correct?
Yes.
And in this case, you identify the victim as she was 8, almost 9 years old, correct?
Yes, when I gave the, that's before we started to talk about this case. I was discussing how children's memories can be malleable. In the mousetrap study, the children were ages 4 to 6. That's before we started to talk about this case. I was just giving the court how research was being conducted, that children can come to believe things that never happened.
My question was that the victim in this case was 8, almost 9 at the time of her forensic interview, correct?
Correct.
Different from, just like you said, in the mousetrap study, that those children were 4 to 6, correct?
That's right.
4 to 6-year-old children are maybe in school, maybe not in school, correct?
Yes.
And the victim in this case, as you said, did not seem to have any developmental disabilities, correct?
Absolutely.
She doesn't seem to have any physical disabilities, correct?
Correct.
She seemed to be a fairly smart 8, almost 9-year-old, correct?
Yes.
Articulate?
Yes.
So when you describe the mousetrap study, you're already agreeing with me that that age group is different than the victim in this case, correct?
That was giving an example of how children's memories, it had nothing to do with this case because that research was on 4 and 6-year-olds. That's before we got into, before the attorney asked me, what did I do in this case? I was just giving the court when he asked questions about memory and suggestibility.
But my question is that you agree with me that the mousetrap study is a different age group than the victim in this case, correct?
Yes.
So that's nothing that you would want to tell this jury about when we get to a jury trial, because it's not relevant, correct?
That's right. I would never bring up this study. I would bring up other ones.
Why is it in your report then, doctor?
Mousetrap studies in my report?
Yes?
Oh, I'm sorry.
You reference it. I'm sorry. Let me take that back. You just talk about CC and Brooke. You don't actually reference the study.
No, what
So
I,
it's your intention to not talk about the mousetrap study
no,
at the trial?
I will not be talking about the mousetrap study.
Because you discussed in your case, in your testimony today, that those children 10 days later were debriefed after the planting of the false memory, correct?
Yes,
But isn't it true that those children were submitted to 30-minute interviews once a week for 12 weeks?
I believe it was 11 weeks and 50, I looked it up in between 58% gave false answers that they were harmed with a mousetrap.
58% gave false answers who had been interviewed for 30 minutes once a week for 11 or 12 weeks, correct?
In that study with 4 and 6-year-olds, yes.
And they were interviewed once a week for 11 to 12 weeks, correct?
Yes,
Different than the situation in the case at hand, correct?
totally.
You also talk about source misattribution, correct?
Yes.
And what are the studies that you're relying on for source misattribution?
So it's in a book written by Kamala London, 2004. It's a chapter called,
Can we just spell for the record, Kamala is Kamala, and London like the city?
correct.
Fine.
Go ahead. I'm sorry.
It's called it's a chapter in a book called Misinformation Effect. The authors are Pickerel, Bernstein, and Loftus. And they talk about how a child can hear naturally occurring events and incorporate them in their own memory. Same thing in Principe, Principe, and Schwinde, Scwinde, 2012. And that talks, I think the name of the article is Naturally Occurring Conversations. And it talks about how children will incorporate, even if they hear their mother talk on the phone or any outside sources. And that's 2012.
Do you have your report in front of you, doctor?
Yes, I do.
I want to direct your attention to page 2 of 3 in the third paragraph where you talk about source misattribution.
Yes.
Do you cite those studies in your report, doctor? In that paragraph where you talk about source misattribution?
No.
You didn't think it was important to include that in your report to the court?
No, my report stands for what it is. A lot of, I knew that I was going to probably be testifying so that I could elaborate.
Oh, so you thought it was a good idea just to mention those studies for the first time today in court, not cite them in your report?
I didn't think it was a good idea. When I was asked a question, I gave a response.
And your report was dated September 9th of 2020, correct?
That's correct.
You cite other researchers, not necessarily studies, in your report, correct?
These are all researchers.
Is that a yes?
Yes, they're researchers. Yes, and I cited other studies.
But in your paragraph about source misattribution, you don't have any sites, correct? Or researchers' names?
No.
And in this case, you listed on the first page that you had a chance to review the Norwalk Police Department arrest and detention report, correct?
And that was a typo.
You
No.
also list that you had 3 tapes regarding Mr. Kenyon.
Yes.
What were those 3 tapes?
Some 2 were different pictures of his house in different rooms, and 1 was him being interrogated.
So when you say tapes in number 5, you also mean the same thing when you list number 7 as pictures?
That I think is a different document.
So the only audio visual tape that you reviewed when you, under number 5 is the interview of the defendant?
But it came in a tape, so that's why I listed it under tapes.
And you had a chance to review all the police reports in this case?
Only the ones I listed.
Well, do you think there are some that you did not review?
Whatever was made available to me, I reviewed.
And let's talk about source misattribution. Can you describe it?
Yes. So if a child hears language that a parent says, like that the behavior was disturbing and illegal, they can incorporate it into their own memory as if it was originated with them. So the memory is distorted by natural occurring information received from, in some cases, teachers, parents, police officers, that the source of, they don't realize if it's their own original memory or is it from what they heard from someone else.
So in other words, it would be somebody telling the victim in this case that the defendant licked her vagina.
I didn't say that. In this case, the source misattribution had to do with calling it disturbing, illegal. I didn't say somebody else. No, I didn't say that at all. What I
So
said,
how does the use of the word disturbing and illegal lead to source misattribution?
that the child is saying it as if it's their own words, but it's
So
words.
those two, so it's not the disclosure, you're saying the words disturbing and illegal, someone else said, and she's repeating those words.
In that specific case, yes. And
Are
that,
you saying that she heard someone else say that the defendant licked her vagina and is accepting that memory as her own?
no,
And you think it's unusual for an 8-year-old to use the word disturbing?
disturbing and illegal, yes.
No, I'm asking about disturbing. My
Yes.
question is, do you think it's unusual for an intelligent, articulate, almost 9-year-old to use the word disturbing?
Yes.
What do you base that on? Because I have a 10-year-old and I don't find it unusual at all.
Objection to that comment.
Sustained, that was argumentative.
What do you base that on?
My history of 40 years of child development, training, treating children, teaching Psych 101. The word disturbing is typically not a word that an 8-year-old would use.
What studies support your hypothesis?
So Suzanne Segroy is well, Piaget, I mean, it's the type of language development, Jean Piaget, Suzanne Segroy, Erickson, developmental psychology.
And so you also say that the word illegal is probably not her word, correct?
Probably heard it somewhere.
You read it in the police reports that her mom said it, correct?
Yes,
After she disclosed to her mother, correct?
I don't know what she disclosed to her mother, only what I saw on the tape because the mother was sitting right next to her.
Well, it's contained in the police reports that you just testified twice that you reviewed, correct?
That's correct.
So you do know what she disclosed to her mother.
Well, I know what her mother reported.
And this is, and you know the circumstances surrounding the disclosure, correct?
I know a brief account of it because I don't know who's in the family. I know a brief account that there was supposed to be a sleepover at the grandmother's house with Abby. But I don't know who's in the family. That wasn't covered in the video.
Well, let's just clarify. You know that she was supposed to sleep over at Allie's house.
Do you
Correct.
mean Abby?
No, I mean Allie.
Okay. I thought her name was Allie. I thought we weren't supposed to use names either.
Not the grandmother's house, but over at her similarly aged cousin's house.
No, I'm not aware of that.
It's in the police reports. Do you recall reading the police reports?
I read the police reports. I did a while ago. I didn't review everything to memory. I definitely reviewed it. They're all highlighted. Can you point me to the page?
And it was in preparation for this sleepover that the victim disclosed the sexual abuse, correct?
Can I refresh my memory? If you can point me to the page, I would like to refresh my memory.
Sure, it's page 6 of 9.
Counsel, can I see which, you may have a different formatted version. I don't see a 6 of 9.
It's,
I have several that are like 1 of 2, 2 of 3, those kinds of.
it's Officer Miller's report, page 2 of 3. The interview of the mother, where she says she was talking with the victim about the sleepover. The victim started talking about the last time she slept over at Allie's house. The victim told her mother that Keith carried her to Allie's bedroom where Allie had been sleeping, unzipped her pajamas, washed her vagina, and licked her vagina. Jill stated that after the victim told her this, she explained to her that what he did was illegal. Does that refresh your recollection, doctor?
I don't have that page.
You might, but counsel, I think you missed the first sentence of that paragraph. Second sentence.
Grandmother's house, not Allie's house then.
Yeah, it actually says that she was going to grandmother's house.
Okay.
And that was my understanding.
Does that refresh your recollection about the context of the disclosure?
Yes, because my understanding was that she was going to the grandmother's house for a sleepover with the cousin.
And the mother said that after the disclosure, she did say the word illegal, correct?
Would somebody point me to the page?
It's a page that has 2 different size fonts. The first half is one size, and then there's a larger font for the bottom half.
Okay, I have it now. Okay.
And counsel was referring to the top part, the first full paragraph, I think.
So when we talk about source misattribution,
So I apologize. Did I answer the question? Because it does say the mother said the word illegal.
okay, I think we agree. Thank you.
Okay.
So when we talk about source misattribution, you're not discussing her disclosure. You're talking about the 2 words disturbing and illegal.
As one deficit in the interview, yeah.
Okay. But you have no independent knowledge that anyone said the word disturbing to her other than the fact that you believe it's unusual for an 8-year-old to use that word.
No, based on my education and training, I taught Psych 101, Jean Piaget, Suzanne Segroy, Erickson, speech development, language development. The child is average intelligence at age 8. The word disturbing is an adult word that it's unlikely that the child said.
So are you saying no 8-year-old would use the word disturbing?
No, I'm not saying that. I said the word unlikely.
Okay. But you have no, outside of this 30-minute interview, you don't have any basis for her language capabilities, correct?
other than my training and experience.
And the mother has already agreed to the police that she said the word illegal, correct?
Yes.
You also discussed how this is an impoverished disclosure in your opinion. You recall that, correct?
Yes.
Do you have any studies that support your sentence? It is counterintuitive that an event such as child sexual abuse was reported with little, if any, detail.
Yes, that's why they have narrative. The reason they have narrative practice events is so the investigator can assess whether the child has a learning disability, level of detail that one could expect. It's a preview on what kind of language you can expect from a child. And
Your opinion that this is a limited detail disclosure. Is that your testimony?
it's not my opinion. When the interviewer talks more than the child, it's a sign of a not well-trained or experienced interviewer. And the narrative practice is where the research is, that we want to know what the child's level of detail can be, what language they use. And it's not a personal opinion. It's an impoverished, she told the police officer in a few minutes the same thing she told the police investigator, and certainly consistency is not predictive of truthfulness. But it's impoverished. It's impoverished. We don't know before, after, the next day, what she did with the underwear, what she did with the onesie. We don't know what her clothes were like. We know that they removed, she changed her answer. They removed a little and a lick.
You would agree with me that there is some detail, though we could disagree to the level, in her disclosure, correct?
There's some detail.
She told you what she did earlier that day, correct?
No, with the self-disclosure, with the sexual disclosure, there's a lot of detail. That's where I have the issue. There's a ton of detail with the video and the field trip. There's a paucity of information about the sexual act, the alleged sexual act. Most of it is from the investigator. The child says the entire story in, I would have to refresh my memory, it can't be more than 2 sentences, but it's elaborated because she's confirming what the interviewer says, and a jury would not know that that's improper interviewing, and it's beyond the knowledge of a jury of source misattribution, leading, suggestive, confirmatory bias, and so on.
So one of the things you just testified to is that there isn't detail about what happened after the assault and surrounding the assault. Do you recall that testimony?
Yes.
So when I asked the question that we know what she was doing before the assault, you completely misdirected it and went on and said that that wasn't relevant.
Oh, I thought you were asking me about the practice narrative. When you
I
said,
don't know why you would think that, doctor. Let me ask if we're confused, let me ask my question again. Isn't it true that she does talk about things she did earlier that day?
Which day are you referring to, counsel?
What did you say?
Which day are you referring to?
The day of the assault.
The alleged assault, okay.
Doctor, did you hear the question?
yes, watching a movie with her cousin?
Correct. That would be a detail. You agree?
Yes.
And she even told what type of detail, correct? What type of movie?
It was the B movie.
Is that a yes?
Yes.
She even gave the detail that in the middle of the movie, her cousin fell asleep, correct?
It's the detail about the sexual disclosure. It's not the detail about what the room looked like. Where there's no robust information is about the sexual allegation. There's no robust information there.
Do you understand my question, doctor?
I do.
Is it your answer a yes then?
It's not I believe it's not relevant to the sexual disclosure.
I get to ask the questions. So my question is, she gave the detail of in the middle of the movie, my cousin fell asleep, correct?
Who gave that detail?
Whether you think it's relevant or not isn't at issue right now. And she gave additional details, correct? About the sexual assault.
She gave a paucity of information about the sexual assault. Most of it originated with the investigator, not with the child.
So you keep saying that, but let's talk about it. I'd like you to turn your attention to page 8. When they're done with narrative event practice, correct?
What part of page 8?
Well, my question is, by page 8, they're done with narrative event practice, correct?
Yes,
They've gone over the rules, correct?
yes,
They've done the promise to tell the truth, correct?
yes.
And you keep testifying that all the information came from the investigator, correct?
Not all. Large originated with the investigator.
Okay. So the investigator says, so do you know why you came to talk to me today? Did I read that correctly?
Yes,
And the victim's response is yes. Correct?
correct.
And the investigator asks, can you tell me why you came to talk to me? Correct?
Yes,
That's an open-ended question, correct?
but can you tell me why you came to talk to me today is either a yes or a no. I don't see how that's open-ended.
Does it suggest an answer?
But either yes or no.
Does it give the child information that the investigator is seeking specifically?
No,
And the investigator, her next answer is okay. Do you see that?
I do.
And then the victim says it's very disturbing, correct?
Correct.
And the investigator says, okay, correct?
Yeah.
That's not a leading question, is it?
I never said that was. I said that was a parentified source misattribution.
No, you're misunderstanding my question, doctor. When the investigator says, okay, that's not a leading question, correct?
Correct.
It's not a question at all, correct?
Correct.
It doesn't suggest any information. Correct?
It could be a validation.
Does it suggest any information?
Yes, that the interviewer also sees it as disturbing. Okay, it's very disturbing. Okay.
So you think that that suggests information, the use of the word okay?
I don't know, but it's a hypothesis that should be explored.
The use of the word okay?
Well, you don't want to reinforce statements of the child. You just want the child to have a free-flowing narrative. It's not a leading question at all. It's just a statement, but it's confirming that it's disturbing. Actually, she could have not. She probably interrupted the child because she should have just went on. It's very disturbing because child wasn't done with the sentence.
Because the victim continued by saying, my uncle did something illegal, correct?
Yes.
And the interviewer says, okay.
Yes.
And the victim's response is, so I wanted to tell you what my uncle did, correct?
Yes.
Now, at this point, the only question the interviewer has asked is, can you tell me why you came to talk to me? Correct?
Yes.
And the interviewer's response is, tell me all about what your uncle did, correct?
Yes.
An open-ended question, correct?
That's an open-ended question.
And in fact, the interviewer didn't even bring up uncle until after the victim said it, correct?
Correct.
So at what point did she suggest any information?
When
On
she,
page 8.
well, I want to I'm going to tell you what I testified to. I didn't testify to anything on this page. When she asked the girl, was the underwear on, off, or something else, that changed the story. That was a major factor that contaminated the child's story. The child's story was the underwear was taken off. After the interviewer asked her, was the underwear on, off, or something else, it changed the story. And then the story continues to, now it's originated with the interviewer that the underwear is not taken off. And, you know, did he use his hands? Did he use his lips? Did he use, not hands, not lips, tongue, skin to skin? Those are the things that originated with the investigator.
At this point, on page 8, you would agree with me that the interviewer has not suggested any information, correct?
I agree.
And in fact, the victim continues with her disclosure, no information from the interviewer, correct?
On page 8, correct.
And continuing on page 9.
Correct. And the entire disclosure is actually one sentence on the top of page 9.
And the victim continues to give information, correct?
Not about the sexual allegation.
Well, you would agree with me that where was your cousin when this happened is an open-ended question, correct?
Is that on this page?
It's on page 9, but I don't think the transcript's relevant for you to tell me if it's an open-ended or closed-ended question.
Okay, please repeat the question. I'm sorry.
Where was your cousin when this happened?
That's an open-ended question.
And it's after the disclosure that there are some more multiple choice questions, correct?
Can you give me an example?
Well, let's turn to page 11. That's a multiple choice question at the top. I heard you say, did you say he took off, down, or something else, correct?
That's the worst question. And you can't unring the bell. The child already disclosed that he took off her underwear. But now the investigator asks it again, repetitive, suggests to the child, I said the research already, to change the answer. And guess what? She changes the answer to, he just moved the part, he moved it a little. That is a question that you cannot take back. Now the story is different. The story is that he didn't take her underwear off, it was just moved to the side a little.
But the question from the investigator is, he took it off, down, or something else. You would agree with me that is a multiple choice question, correct?
Yes,
It is not a leading question, correct?
it's a confirmatory bias question. And it is leading, it's giving her other options. She already said he took her underpants off. Now she wants to ask her, were they down or something else? It is leading because obviously the taking her pants off, the investigator didn't accept it and asked it again.
You testified that you're familiar with the Wisconsin guidelines, correct?
Yes.
They're allowed to ask clarifying questions in the Wisconsin guidelines, correct?
They're not allowed to suggest, the question was answered already.
Ma'am, they are allowed to ask clarifying questions, correct?
Absolutely.
They're allowed in the national guidelines to ask clarifying questions, correct?
We encourage that.
Say that again. What was the answer, doctor?
We encourage clarifying questions. We encourage, we look for.
Let me interrupt for 1 second. It's 4:50. I was thinking we'd easily finish this today. Now, as you both know, I do my best not to get in touch with the chief judge, sometimes more successfully than others. But, so we're not going to go past 5. So I just want to know where we stand. Ms. Carson?
I don't think we're going to finish today, Judge. I'm sorry.
See, I was picking up on the same thing. All right, we'll let Ms. Carson ask a few more questions. We'll stop in maybe 4 or 5 minutes, and then we'll pick up where we left off and calendar accordingly. Go ahead.
Thank you. So your concern with multiple leading questions is that it would suggest an answer, correct? And then the child would accept that answer.
My concern was that the child answered the question already, and the answer is not consistent with, it's nonsensical that he could have access to her vagina without taking her onesie off. So the interviewer asks a question again, and it suggests that she did not give the right answer. So now the interviewer suggests, did you say he took it off, down, or something else? So the child changed her answer. It is perfect with the research. The child changed her answer when the police officer asked her it again.
My question is that the concern with leading questions is that children are suggestible, correct?
Yes.
None of those options that the interviewer gave is one that the child adopted, correct?
She adopted something else. It is, she modified her answer, which was completely different than her first answer.
Okay, so doctor, if we're talking about suggestibility and your whole premise is that children's minds are malleable and suggestible, and that's why we have to be so careful with the interviews, how did this child adopt the something else?
Okay, the way she adopted something else, well, you asked the question if an answer was suggested. She already said her underwear was taken off. When the investigator asked it again, because it was nonsensical without having to take the whole onesie off, she said something else. This is where Istanbul and Blades, repetitive questioning, and it's Poole and White have repetitive questioning, I think 2001, that a child will change their answer if asked again, and an authority figure. So it's not my whole premise, but my premise is that this worked just like clockwork, but what the research says. She changed her answer to a really drastically different answer.
One
You
or
would
two more
agree with-
follow-ups. One or two follow-ups, and we'll break. It's almost 5.
You have concerns with leading questions and suggestibility, correct?
In the totality of circumstances, I have issues. The protocols tell us no leading, no suggesting, no confirmatory bias, use alternative hypotheses, use clarifying questions, use anatomy if you don't understand, find out who lives in the family. Those are the things that I have the concerns with.
And one of the concerns is that the child will just blanketly adopt the interviewer's, say yes to please the interviewer, correct?
Not in every single thing, but here it's clear, and this is the major focus. She did, when she said use tongue, the child didn't adopt it. Use your tongue on anything else but she did adopt skin to skin. She did adopt a lot of what the interviewer said.
Oh, you think she did? Okay, so when the interviewer said, did anything happen with hands? And the victim answers no, she's not adopting what the interviewer said, correct?
No, she's not. But when
Thank you. That answers my question. My next question is.
Next and last for today. It's almost 5.
When the interviewer says, did anything happen with mouths besides licking? And the victim responds, no, she didn't accept the interviewer's premise, correct?
Correct.
Great. We'll break there. Madam Clerk, we'll calendar. We need to finish this testimony with the doctor. We need to discuss the other 2 motions that I discussed earlier. The motion to dismiss that was filed over a year ago, and the motion regarding the state's potential expert. I'll try to handle those all, hopefully at the same time or the same day, subject to length and other time constraints, but Madam Clerk,
March 29th or 31st in the afternoon?
Your Honor, I'm going to go get my calendar.
sure.
Counsel, do you know approximately how much longer on cross do you think for this witness? Because then we'll need time for your witness.
I would anticipate at least another half an hour.
Your witness, based on the disclosure, doesn't have a real long number of topics, so maybe an hour, I would hope, for direct and cross on her, do you think?
Sure.
So about an hour and a half.
We'd start at about 1:30 or 2 o'clock either day.
I'm
Okay.
sorry, what were the days again?
The 29th or 31st of March at 1:30.
I have
2 o'clock.
Off the record, as I'm sure you guys know, when it comes to scheduling, at least I, as a judge, whatever the lawyers estimate, I add at least 50% to that. So if we're saying an hour and a half or 2 hours, realistically, we're probably looking at 2.5 hours because
Okay.
we also need to discuss the motion to dismiss. So we'll look for one of those 2 days. Go ahead, Janelle.
Madam Clerk, unfortunately, I have 3 speedy trials that Monday. I think it's reasonable that one of them would go. I mean, who knows, really? But
We're looking for an in-person date on your calendar? Okay.
Yeah, April 14th, 10 o'clock or 9:45.
9:45 is okay with me on the 14th. I don't know about Dr. Bashkoff's schedule.
Doctor, does April 14th in the morning work?
9:45.
That's 10:45 your time.
I was going to say 9:45 our time, so I think you're out east, correct?
Yes.
Actually, I know that. I read the CV.
Yeah,
Albany's in New York. I know
can-
that. I'll
I
take
can-
initial notice. 10:45 for you, that works, Doctor?
it does, thank you.
All right.
Ms. Kirshen?
the best I can do is I have 3 trials set that Monday. I can alert the parties if I'm in trial.
All right, well, why don't we set it and we'll, hopefully, everybody will be available.
April 14th, 9:45, motion hearing back here in room 506.
Did you hear that, Doctor? It'll be 9:45 our time, 10:45 your time,
I
April
did.
14th. Same link to my Zoom video situation.
Thank you.
You're welcome.
Judge, could we talk off the record just 1 minute about the courtroom setup for trial?
Sure.
You'll notice today we don't have, I don't have an attorney-client interpreter with me at counsel table. I would need that at trial, and I need 2, both a hearing and CDI. And what I've been told is that we would need to be, I guess if we have plexiglass, we probably have to have another table next to this one, abutting it with a 3rd divider in the middle. I don't know how, do we have a 620 is probably not like that now.
Judge, it's March and the trial's not till July. I mean,
I know, we don't have to spend a lot of time on it. I'm just kind of alerting people, the parties now in the courts, because we are going to need some advance notice for a physical layout, is all I'm saying.
I will make whatever accommodations are appropriate and necessary. You know.
620 has a whole additional table. It's set up for co-defendants. It's fine.
There is